Welcome to another installment of Employee Termination Tips. My name's Christopher Neufeld of Neufeld Legal, and in this particular video, we're going to be discussing what to do as a fired employee right after you've been fired and you found access to your computer at work shut off, your cell phone shut off, your emails inaccessible with the company. What do? Well, what you should be doing is requesting from the person who you met with access and copies to all your employment-related records. Now, there's a fair amount of employment-related records that you need, especially when you're trying to determine what to do with respect to taking a proposed termination severance pay package. And a lot of this stuff is required to be retained by the employer pursuant to the applicable employment standards legislation, and in truth should be accessible to you as an employee. And even though you are fired, you are still an employee under the relevant legislation. So what are you looking to do? Well, you're looking to request copies of all your pay statements, earnings information, all contracts and agreements. So what can this include? Well, it can include everything from what arrangements were in place with respect to your pay, your earnings, vacation pay, changes to your vacation pay, what your wage rate was, what your overtime rate was, changes to that overtime, and any particulars relating to those changes. You also want to get any documentation related to a temporary layoff or a leave that's in the possession of the employer. You also might want to get overtime agreements or averaging agreements if they exist, consent forms, permits, and other types of agreements that may have come into play, such as variances or permission forms or other suggestions that were made by your employer that pertain to your record. Anything that is in your record, even manuals and policy guidelines, you want to just put the request in there, and at the minimum, if they're not agreeable to providing you with those materials, at least you have it on record, and you have a record showing that they're unwilling to provide you with core materials that pertain to your employment and pertain to your making a determination as to whether or not you are going to accept their proposed termination and severance pay package, and whether you are able to properly understand what your rights are and whether or not you're being treated fairly by your former employer. So you want to make this request. You want to make the request not necessarily by phone, and if you do make it by phone, you want to follow it up with an email so you have a record of it. You want to make clear that you are requesting this material. Go to your particular employment standards legislation. You can look generally in the first few pages. They'll have a list of the records that employers are required to keep, and also information with respect to what the employer is required to provide. The requirements are oftentimes very interesting. Of note, when you request information, you might not just simply be asking for what you previously had, but information you might not have been fully aware of and the employer is not fully aware of. One of these very interesting particulars is how an employee's earnings were calculated and the method for calculating bonuses and living allowances that were paid to the employer, and whether or not they formed part of their wages. This is critical information to the right lawyer to determine what has happened with respect to your employment pay history and as it relates to the determination of the appropriate calculation for termination pay in lieu of notice and severance pay. And the decision by the employer and oftentimes their internal legal counsel and even their outside law firm and legal advisors will shed a lot of light onto where you stand relative to making a proper determination and whether you should take a further step and be prepared to challenge them. If your former employer is being transparent with yourself, they will follow up with your requests, feeling full well that they have nothing to hide. The problem arises when your former employer decides that they're not going to provide you with the information and the materials that you're requesting. Yes, certain materials might not be readily available or might not technically fall within the ambit of being required to be provided. But then again, there are other materials that do have a legal requirement to be provided to yourself. And when the employer is taking the position that it need not provide you with that information, well, that creates a very tenuous position, and it suggests that there is something that they are looking to hide or they are not wanting to disclose. And they're hoping that by refusing to provide you what is legally required, you'll simply say, throw up your hands and accept the fact that they're not going to provide it to you. However, if you do challenge them, right away you've identified a major issue and a major transgression on their part, where they're not just simply challenging some judge-made law. What they are doing is they're operating in violation of legislation specific to employment standards. And that is not appropriate, especially when it's coming from legal counsel, whether internal legal counsel or external legal counsel. When they decide not to provide you with important documentation that you're legally entitled to, it shows that there might be something more there. And unfortunately, they're positioning themselves to be challenged on a legal basis, and that the right lawyers will be able to utilize that to your advantage. You want to understand where you stand and how to proceed. And by requesting this information, you're going to get a good sense of where they stand and whether or not they're trying to just push you out without giving you stuff, or if they're willing to work with you and they're trying to be transparent. Because if they're trying to be transparent, they give you all the information, there might not be much there. But when they close you off, that is when the alarm bell should sound, telling you that there is something amiss and that you need to truly dig into it further and consult with the appropriate legal counsel. You should consult with the lawyers irrespective, but when they're cutting you off from information, they're dismissing you after they've relieved you of your job, that is something very important for you to look into and to deal with. And that is our professional recommendation to yourself. Thank you.